Mr. Patel, Goldman said, his voice cutting through the packed chamber like a blade, does Donald Trump appear anywhere in the Epstein files? The room stopped breathing. Patel blinked. He leaned toward the mic and said he hadn't heard the question. I'm sorry, could you say that again? Goldman didn't flinch. It's not a complicated question. Does Donald Trump appear anywhere in the Epstein files? And right there, in that split second before Patel answered, something shifted in the room because everyone watching, reporters, staffers, senators, millions at home, could see it. The confidence he walked in with had cracked just slightly, just enough. That moment wasn't just about Epstein. It was the surface of something far deeper, something prosecutors had already locked away in a sealed transcript, something that had turned Donald Trump's most loyal defender into his most dangerous liability. Think about what that relationship meant. Trump didn't just hire Patel, he built him, pushed him into position after position over fierce institutional resistance. Patel had defended Trump publicly when almost no one else would, called every investigation a political hit job, appeared on television to vouch for decisions that others refused to touch. In return, Trump made him the director of the FBI, the ultimate reward for ultimate loyalty. They weren't just allies, they were a pact, which is exactly what made what happened next so devastating. To understand what really happened in that room, you have to start somewhere else entirely. You have to start with a quiet federal courtroom, a subpoena, and a man who thought silence would protect him. When the Mar-a-Lago classified documents investigation went federal, prosecutors needed one witness more than any other: Kash Patel, Trump's former chief of staff at the Department of Defense, the man who was physically present for decisions about how classified materials left the White House. The man who knew the timeline, the conversations, the chain of custody. The DOJ summoned him to the grand jury. Patel showed up. And then he did something that told prosecutors everything they needed to know. He invoked the Fifth Amendment, said nothing, refused every question. As long as he stayed silent, Trump's defense held. But the Department of Justice had already anticipated this move. In November 2022, prosecutors walked into federal court and asked Judge Beryl Howell for a use immunity order. This is the legal equivalent of removing someone's escape hatch entirely. Under use immunity, anything Patel said under oath couldn't be used to prosecute him personally. His Fifth Amendment protection evaporated. He had to talk, and every word he spoke could be used directly against Donald Trump. Judge Howell agreed. Patel sat back down. This time he had no shield, no Fifth Amendment, no silence. Just a federal oath and prosecutors who had been waiting months to ask him every single question he'd been avoiding. What came out of that room destroyed the narrative Patel had been building in public for years. Because on television, Patel had been relentless. Standing orders, full declassification. Trump had done everything by the book. He said it with conviction on major networks, repeatedly. Building a wall of public testimony that was supposed to make the legal case impossible. If the man who was there said there was no crime, maybe there wasn't one. But under oath, with immunity protecting him and perjury charges waiting for any lie, the story changed. Prosecutors didn't want speeches. They wanted procedures. Which documents proved declassification actually occurred? Who was notified? What steps were followed? In what order? With what written record? There were no documents. There were no steps. There was no standing order. The wall Patel had built in public collapsed in that grand jury room, quietly, permanently, on the record. Now back to that hearing, because Patel didn't just face Goldman's Epstein question. He faced a barrage that exposed something even more alarming: how little control he had over his own story. When Goldman pressed on the court orders Patel cited as the reason for withholding information, Patel reached for legal cover. He claimed search warrant restrictions. Goldman shut it down instantly. That's not what the court order says, and that's not under 6E. Patel tried again. I said that's 6E, and I said there were others. Goldman came right back. They are unsealed as part of discovery, given to Ghislaine Maxwell. They are no longer sealed. Patel's jaw tightened. His answer had been wrong, publicly, on camera, in front of the committee. But that wasn't the most damaging exchange. Watch what happened when senators shifted to internal FBI operations. Another member leaned into the microphone and asked how many FBI personnel had departed since Patel took over. Simple question. Direct question. Patel bristled. That's not my testimony, he shot back. You asked it one time, I answered it one time. You didn't get the answer you wanted for your clips. Keep asking it. The room went sharp. That sentence, you didn't get the answer you wanted for your clips, wasn't a defense. It was a tell. A man who has clean answers doesn't say that. A man with clean answers gives the number and moves on. Pressed on which field offices had grown under his leadership, Patel finally offered the greatest allocation, I believe, was given to California and then Florida. Vague, hedged. A man who runs a $10 billion federal agency estimating his own budget allocations. Then came the question that should have been the end of it. A senator leaned forward and asked directly, "Did you testify before the grand jury that President Trump had declassified the documents at issue in the Mar-a-Lago classified documents case?" Patel's answer was extraordinary in what it refused to be. He said he didn't have the grand jury transcript. He said whatever it contained was the best evidence of what he'd said. He offered to work with the DOJ and the courts to have it released. He filled the silence with procedure and process and careful language designed to say nothing at all. The senator pressed. The court said, "You are free to discuss your own grand jury testimony. So I ask you again, did you testify that President Trump's declassified those documents?" Patel's hands shifted on the table. His voice stayed controlled, but the words were a retreat. "That is why I took your invitation to work with the department and the court to have that transcript released." He never answered the question. Not once. And then came the Schiff exchange, the moment when the composure finally broke completely. When Senator Adam Schiff pressed on the contradictions mounting in real time, Patel turned to him and said it directly. "You are a disgrace to this institution. Not measured, not strategic, raw." That was not a man in control of his situation. That was a man who had been cornered and had stopped performing calm. Because here's what Patel understood in that moment, and what everyone watching needed to understand too. He wasn't just defending himself from Schiff's questions. He was calculating in real time how to survive a situation where his public statements, his grand jury testimony, and his current testimony were all pointing in different directions. And at least one of those directions led to perjury. The confirmation hearing had already exposed the same fault lines. Senators grilled him about the grand jury testimony. What did he tell prosecutors? Did he contradict Trump's declassification story? Did he provide evidence of obstruction? And Patel did something that legal analysts flagged immediately. Without anyone accusing him of a crime, he stated, unprompted, that he had done nothing wrong. Not once, multiple times. Insisting on his own innocence into a silence that hadn't asked for it. He also claimed he couldn't recall the specifics of his own sworn testimony about one of the most significant federal investigations in decades, about words he personally spoke under oath. A former federal prosecutor watching the hearing said it plainly. When someone can't remember their own testimony on something this important, they're not forgetting. They're calculating. The DOJ's strategy here wasn't improvised. It was a blueprint they had already used successfully. They immunized Alan Weisselberg, Trump Organization CFO, and walked away with financial testimony prosecutors are still using. They compelled Trump's own attorneys to testify about legal advice that should have stayed sealed. They put Mar-a-Lago staff under oath and built a precise record of how classified materials were stored, moved, and hidden from federal investigators. Each immunity deal flipped one more insider. Each insider brought one more piece of the structure down from the inside. Patel was the final piece, the loudest public defender, the most visible loyalist, the one whose television statements were most directly contradicted by what he said under oath with immunity. Trump cannot reverse this. Executive privilege collapses in the face of criminal conduct. Attorney-client protections vanish the moment they're used to cover a crime. No political statement or media campaign touches a sealed federal transcript. And intimidation of immunized witnesses is obstruction, another charge. Every exit is closed. There's an old principle in federal prosecution. You don't need the most loyal person in the room to turn on the target. You just need to give them a reason to stop lying. Use immunity was that reason. Kash Patel is not naive. He is a trained federal prosecutor who understands exactly what grand jury testimony means, exactly what perjury costs, and exactly what is written in that transcript. He made a calculation in that room, the calculation that telling the truth was less dangerous than protecting a man who could no longer protect him back. Donald Trump built his entire Mar-a-Lago defense around one story. That story required Kash Patel to keep telling it. Patel told it on television, in interviews, on social media, everywhere except the one place it actually mattered, under oath. Now prosecutors have the real version, sealed, signed, and waiting. And here's the question that should be keeping everyone up at night. If Patel's grand jury testimony actually supported Trump, if it confirmed the declassification story, if it proved the documents were handled lawfully, why won't he just say so? He's free to discuss his own testimony. The court said so explicitly. He knows this. So why keep hiding behind secrecy rules that don't apply? Why does he keep insisting he committed no crime when nobody asked? Drop your answer in the comments. Is Patel protecting himself now? Or did he already make his choice the moment he walked into that grand jury room? Because one thing is certain, somewhere Donald Trump already knows the answer. And whatever he's feeling right now, it isn't gratitude. The most powerful law enforcement agency in America is now run by a man whose sealed words may be the final nail in his former boss's defense. That's not political spin. That's the result of a DOJ strategy that took years, multiple immunity deals, and one very carefully constructed trap. Trump can call it a witch hunt. He can post about deep state conspiracies at 3 a.m. He can rage at senators on live television through his surrogates, but he cannot reach into a sealed federal courthouse and rewrite what Kash Patel already said under oath. That testimony exists. It cannot be walked back. It cannot be threatened into silence. And the trial clock is already running. There's a reason Patel looked the way he looked in that hearing room. There's a reason he snapped at Schiff. There's a reason he keeps repeating, unprompted, that he did nothing wrong. A man with a clean record doesn't act like that. A man who gave testimony that helped his former boss would be eager to say so. He is not eager. He is evasive. And in Washington, that's the loudest answer of all. The betrayal wasn't dramatic. It didn't happen in a press conference or a leaked memo. It happened in a quiet federal room with immunity papers on the table and a court reporter typing every word. It happened the moment Kash Patel stopped protecting himself with silence and started protecting himself with truth. That's how the most powerful partnerships end in Washington. Not with a fight, with a transcript, 6 prosecutors, 2 immunity deals, 1 sealed transcript, and a former loyalist who, when given the choice between protecting his boss and protecting himself, made the only rational decision a trained federal attorney could make. Donald Trump is going to have to stand in front of a jury, and the man who was supposed to be his shield has already become the prosecution's most important exhibit.